satisfy the court that this could be the reasons why I was this particular para was avoided by the litigant in original plaint, right? So order 7 talks about plaint. So it outlines the mandatory particulars for a plaintiff draft, including facts, jurisdiction, and relief. Crucially, dictates ground for outright rejection of a defective plaint. So as I said, 711. 711 is an important application which the defendant takes if the defendant wish to cancel the claim of the plaintiff or defend the claim of the plaintiff. Order 8 talks about the written statement, set off, and counterclaim. So written statement, as I've already mentioned in module 1, written statement is nothing but a reply to the plaint which the plaintiff has filed before the court. Now set off. Set off is very important. That falls under the rule 6 of order 8. So set off is nothing but a connotation that is being used by the legislature to set off the claim. Usually set off is used in a monetary claims. Let's suppose if I owe plaintiff 10 lakh rupees. All right. Being a plaintiff, I owe 10 lakh rupees to defendant and I have filed 20 lakhs claim recovering the amount. So the defendant can file a set off. Let's suppose let's take it the other way around. So being a plaintiff, it's a money decree. I have provided defendant 10 lakh rupees a loan. All right, and I moved an application. I moved a plaint before the court, and subsequently the notice were issued to the defendant. Now defendant take a plea that defendant had also given me 5 lakh of rupees in the same transaction, in the same course of event. It is very important to show the court that everything happened on the same transaction, right? Then only you can seek for a set off. So if I, being a plaintiff, claim for a 10 lakh rupees as a recovery amount from the defendant says that I have also provided the plaintiff 5 lakh rupees of loan, so the court will set off the amount. Now my claim would become only of 5 lakh rupees. I cannot claim 10 lakh rupees because the 5 lakh rupees has already been set off by the court, right? So there are two types of set off that has been recognized by the common law, the Indian courts. That is legally set off and equitable set off. So legally set off is something where the amount is ascertained. Like as if I told you, if I have a claim of 10 lakh and the defendant has also provided me a 5 lakh rupees of loan, then he can set off the remaining 5 lakh rupees from the court. That's legally set off, right? What is equitable set off? So equitable set off is something where the amount is not ascertained. In such scenarios where there was a contract, let's suppose, and I have breached the contract. So the opposite party is claiming the damages from me. So in my written statement, I can seek other damages because of the delay, that the plaintiff delayed the amount, delayed the delivery, and due to which I incurred damages. So in that scenarios as well, the court has a power to provide equitable set off, right? So that is the term equitable set offs come into the play. Now, what is counterclaim? So counterclaim is a separate cause of issue. Counterclaim is nothing but counterclaim may be defined as a claim made by the defendant in a suit against the plaintiff. It is a claim independent of and separable from the plaintiff's claim, which can be enforced by a cross action. It is a cause of action in favor of the defendant against the plaintiff. It does not mean that it has to be a money decree. The counterclaim can be made to plaintiff in any manner. Let's suppose I and defendant had a transaction, and I am seeking relief from the court for pertaining to that same transaction. And in some other transaction, the defendant has a claim against me. So in that scenario, the counterclaim be registered as a separate suit, not along with the main plaint which I have filed, being a plaintiff. Right? So that is the counterclaim. Order 9 talks about the appearance of parties and consequences of non-appearance, details outcomes of hearing dates, including dismissal of suits for plaintiff's absence and ex parte decree for defendant's non-appearance. So let's suppose I file the case, I am not appearing before the court can dismiss the suit for non-prosecution. All right. And subsequently, if the defendant is not appearing before the court, then the court can pass the ex parte decree. Now, the court can only pass ex parte decree when the notice or summon to the defendant is executed legally, or is, the summons has been procured to the defendant and he has taken the summons. So once the notice was issued and the defendant has also taken the notice from the court and still he is not appearing before the court, then the ex parte decrees can be given by the court for non-appearance of the defendant. The examination of Order 10 talks about the examination of parties by the court, empowers judges to directly question parties at the first hearing to pinpoint disputes, integrating mandatory directions for alternative dispute resolution. So basically, this is nothing but at the first instance, the court has the power. Of course, the court has numerous power. It has a power to directly ask the question to the plaintiff: "What is your dispute? Why have you come before the court?" If the defendant has made his appearance, then the court can ask directly to the defendant. And if the court finds it suitable, they can refer to the alternate dispute resolution. There is mediation before the mediation court. So mediation is not a court basically, but is a designated place where the mediation can happen if both the parties can amicably decide and settle their disputes. So that's the mechanism we usually courts take, because it nullifies the long process of litigation. So the common drafting mistakes which every young lawyers make is discontinued fact, jumping erratically between timelines, or dropping crucial narratives thread without a resolution. This breaks the logical sequence, making it incredibly difficult for the judge to track the exact events, establishing the cause of action. Paragraph shifting, mixing multiple distinct ideas, legal arguments, or overlapping facts into a single lengthy paragraph. This creates ambiguity for the defense reply and complicates the court's framing of issues. Rule of thumb, brevity is the key. Never make pleadings unnecessarily lengthy. See, I would suggest you to make a plaint very crisp and clear. Put forth the facts in a continuing manner. Then put forth the cause of action para, then your jurisdiction para, and your limitation para. That's it. And the prayer clause comes at the end. Right. So structure of a legal draft, a well drafted legal pleadings adheres to a specific structured format, ensuring all crucial elements are systematically presented to the court. This chronological flow is vital for clarity and legal efficacy. So first, the fact, a concise chronological narrative outlining the events that led directly to the dispute and form the basis of the claim. Then jurisdiction clause explicitly states the court's authority, both territorial and pecuniary, which I have discussed in module 1. You must be aware what the territorial and pecuniary jurisdictions are to hear and decide the specific matter presented. Cause of action clause clearly pinpoints the specific legal wrong committed. See, cause of action clause is important because that justifies your claim. Also provides you the timeline for limitation. So the cause of action clause is very, very, very important. The court also at the first instance asks you, what is your cause of action? When did your cause of action arise? Because from that period of time, your limitation starts. And from that period of time, your right to sue arises. The right to sue accrues. So there is the reason why this clause is very important. So pinpoints a specific legal wrong committed, including the date and location where it arose, establishing the grounds for relief. Limitation clause in civil suits, it is very important because certain civil actions has their own limitation period. Let's suppose in recovery suits, 3 years of limitation is there, right? Affirms that the suit has been filed within the legally prescribed statutory period, preventing dismissal on grounds of delay. If you're not filing your suit within a statutory limitation period, the court has a power to dismiss your suit at the first instance. Then the prayer clause comes, a precise statement detailing the exact final relief or remedy being sought from the court, such as damages, injunctions, or specific performance. I believe prayer is very common. What is your relief? Whatever you are asking before the court, you can put forth in the prayer clause. So components of a legal documents, A case information format, that is very important. You have to put forth a case information format, the name of the parties, the addresses, and so and so. Then comes the index part. Then the memo of parties. Memo of parties is nothing but it is a memorandum of parties, or you can say like a detail of the parties, their addresses, father's name, so and so, and then the court fee. The court fee is important in civil matters. Without the court fee, a suit may be dismissed. Then comes the plaint. Then supporting affidavits. Every plaint should be verified and supported by an affidavit. Then list of documents pertains to your claim, your supporting claim. I mean the documents which supports your claim. And then wakalatnama. Wakalatnama, you must be aware that wakalatnama is nothing but it eventually gives a lawyer to represent your client before the court. Formatting and presentation standards. Usually the formats that has been follows throughout the Indian judicial system is it requires a pleading to be typed in Times New Roman, a font size at a 14 point size, and usually line spacing should be kept at 1.5 foot double space, accompanied by fully justified text lines. Right? And that's all. Thank you.